Katerina on AM 560, The Answer.
Get the latest weather, traffic, and news updates online at 560theanswer.com. Now, from the Signature Bank Studios. If you're looking for the latest news, insight into what it means, and the sharpest opinion, there's only one station in Chicago where you can turn, and it's this one. We're AM 560, The Answer.
Top of the morning, Dan Proft here. Interesting development in the case against Jim Comey, former FBI director, for lying and obstructing justice. Lying under oath. Pat Fitzgerald. You remember Pat Fitzgerald? Lincoln is rolling over in his grave, the Blago prosecution, and so forth. Yeah, former U.S. attorney for the Northern District here. A very uneven record as U.S. attorney. Hardly the Elliot Ness he was cracked up to be when he came to town. Anyway, the state is suggesting that Pat Fitzgerald should have to recuse himself as being the lead attorney for Jim Comey because he's conflicted out. They cite a 2019 Department of Justice watchdog report that found Comey leaked information to Fitzgerald. The Inspector General concluded Fitzgerald received multiple Comey memos about his meetings with President Trump, including at least one memo containing classified information. There he goes again, that Jim Comey. It wasn't just Richmond, it would appear. Catherine Herridge reporting on this, great investigative journalist. 2019 Justice Department watchdog concluded Comey set a quote-unquote dangerous example when he shared personal memos documenting his private meetings with President Trump about the FBI's Russian collusion probe. According to the Inspector General, several memos were shared with Columbia law professor Daniel Richmond. Richmond is expected to be a central witness in the pending federal prosecution against Comey for lying about his role in media leaks. The Inspector General also found Attorney Patrick Fitzgerald received multiple Comey memos about the Trump meetings, including at least one memo containing classified information. So is there a conflict or appearance of conflict, or do you want your lead attorney being called as a hostile witness by the state in your trial? Well, let's get some legal perspective on this matter. Pleased to be joined again by George Parry, former federal and state prosecutor, regular contributor to the American Spectator, and George blogs at knowledgeisgood.net. George, thanks for joining us.
Well, good morning. Thank you.
So, how about that apparent conflict that Pat Fitzgerald had? Should he step aside as legal counsel or be compelled to?
Yeah. Look, a lawyer cannot be both an advocate and a witness. If he's going to try the case, he cannot testify. He should not be a person who's a potential witness. So I would say that based on what we know so far, he is absolutely disqualified as counsel in this case because the government could call him as a witness.
I would think they would want to, right? Why wouldn't the government, even if he is going to be hostile, why wouldn't the government call him if that IG report is correct?
Yeah, absolutely. Absolutely. I mean, the great relief in all of this is that there had been some question as to whether or not the Comey case was based on Andrew McCabe, the former deputy director of the FBI, and his activities. And now apparently the case is based on what Comey did with that Columbia law professor. So that's a much stronger position for the government. And if Fitzgerald had received any classified information from Comey on an unauthorized basis, that makes him a potential witness, and therefore he cannot serve as counsel for Comey in the trial of this case.
It also perhaps establishes a pattern. Sean Davis pointed this out at the Federalist. It's a long-time tactic of Comey's. He hires attorneys he leaks to, then pretends they can't be questioned because of attorney-client privilege. He did the same illegal arrangement with Daniel Richmond, the Columbia professor, that he did with Pat Fitzgerald.
Mm-hmm. Yeah. Well,
it speaks to someone who is, less than the paragon of integrity that he presents himself to be.
Yeah, and look, the attorney-client privilege is a wrinkle in all of this, but the attorney cannot testify to communications that he's had with his client. However, he can certainly testify to the actions of his client, and if the allegation here is that Comey provided classified material to Fitzgerald, Fitzgerald can testify to that. He may be prohibited from testifying as to what Comey said to him when he was seeking legal advice, but as far as Comey's actions, he can testify to that. And it'd be like me representing a bank robber, and I saw him rob the bank. Well, they can put me on the stand and say, what did you see? And that's not covered by privilege. I would have to say, I saw the guy rob the bank. Same thing here.
So do you find the case, I mean, given what we know at this point, do you find the case against Comey pretty compelling?
Well, yeah, except there's the one problem that I see with it. It's based on Comey's testimony before the Senate. And the problem with all of this is that nobody in the Senate, with the exception of maybe Josh Hawley and Senator Kennedy from Louisiana, know how to question witnesses. And this case appears to be based on questioning by Senator Ted Cruz, who's better than most of those guys in the Senate when it comes to questioning. But the questioning by Cruz was, from my standpoint, very imprecise in many ways and left a lot of wiggle room for the witness, for Comey. And so I think they're going to have some difficulty there making it stick. You want to have sharp, short, and clear questions and clear answers. And if you look at what Cruz was doing, he was trying to draw a dichotomy between what Andrew McCabe had to say about leaks and what Comey had to say about leaks. And I thought it was just kind of mushy. So I think they got a problem there. But no, they've got enough evidence to go to trial. And I think that, Comey is going to be in for a rough ride. But can they make it stick before a jury? I'm not so sure.
Yeah, I mean, it is worth noting just because of what I described from Catherine Herridge's reporting about the memos to Patrick Fitzgerald, one of which include classified information. The charges against Comey are making a false statement and obstruction. There's no mishandling of classified information charge. If people were thinking, well, that opens up a whole other, that provides more exposure, but that's not one of the charges against him. So,
yeah, and I think that's a real weak point. So.
Wanted to get your take. I had this discussion yesterday with Professor Richard Epstein from University of Chicago, and we have different views on this, and it's always intimidating when you're talking to Richard Epstein. But nonetheless, federal district court judge seems to be going my way and not Professor Epstein's. So Trump can stage National Guard in Portland, just as he is staging them in suburban Chicago. No relief on the TRO that prevents deployment in either city. But it seems to be moving in the direction of Trump through the courts in terms of his ability to deploy the National Guard, even against local objections, in support of federal law enforcement enforcing federal law, particularly when you have violent acts being committed against federal law enforcement officers, as has happened both in Chicago and Portland.
Yeah, and the Ninth Circuit, a panel of the Ninth Circuit, overturned that temporary restraining order and said that Trump can go ahead and deploy troops in Portland. And this was a 2-1 panel decision. If the case is appealed to the full Ninth Circuit, which is kind of a Fruit Loop circuit court, it could very well be overturned, and then it would have to go to the Supreme Court of the United States. But the fact of the matter is, the president's authority to deploy troops to protect federal facilities and to deal with disorder is crystal clear. And I mean, if you go back to history, just look at the history of this thing. President Eisenhower nationalized or federalized the Arkansas National Guard in 1957 and sent in the 101st Airborne Division to integrate Central High School in Little Rock, Arkansas. And that military occupation of Little Rock, Arkansas lasted for 8 months, with both paratroopers and National Guard remaining on scene. They did the same thing at the University of Alabama and Ole Miss, University of Mississippi, to integrate those schools. They sent in regular Army troops in addition to the National Guard. And you can go on and on and on. There have been about over 30 times in our history when the president, on his own authority, has sent in troops to maintain order and to accomplish a federal purpose. In the case of Little Rock in Mississippi and Alabama, it was to enforce integration orders. But there's no question that the president has this authority, and the only reason this has become an issue is because we've got a lot of district court judges who have an outsized opinion of what their authority is in these matters. There's no question that Trump can do this, and it's not going to get resolved definitively until it winds up before the Supreme Court of the United States. And I'm confident the Supreme Court of the United States will uphold Trump's authority to deploy these troops.
And he has not invoked the Insurrection Act, but he's not taking it off the table either. This is what he said to Maria Bartiromo over the weekend.
And don't forget, and I haven't used it, but don't forget, I can use the Insurrection Act. 50% of the presidents almost have used that. And that's unquestioned power. I choose not to. I'd rather do this. But I'm met constantly by fake politicians that think that, it's not like a part of the radical left movement to have safety. These cities have to be safe. Our cities that are Democrat run, exclusively just about, are unsafe cities.
Is Trump right to resist the temptation to invoke the Insurrection Act at this point?
Well, I'd never question his wisdom, but as far as I'm concerned, he absolutely has the right to invoke the Insurrection Act. It's a mystery to me why he hasn't. I mean, when he's talking about going into Chicago to do for Chicago what he's done for the District of Columbia, I wrote an article for the American Spectator, and I went into the history of the Insurrection Act. The fact of the matter is that act expressly authorizes the president to use military force to suppress domestic violence that threatens the rights of others when state authorities either cannot or will not maintain order. And the president has broad authority under that act to determine when conditions warrant invoking the act. And courts, the case law on this goes all the way back to the 1840s. The courts defer to the president's authority in terms of whether or not he has made a good faith judgment that deployment of the troops is required. So if you look at what the mess that is going on in Chicago, the lawlessness, just, forget about what's going on out at the ICE facility in the suburbs. Just look at the general lawlessness that's going on in Chicago. I maintain that Trump could invoke the Insurrection Act to send troops into Chicago to help suppress crime. And I think that I don't know why Trump has not invoked the Insurrection Act yet, but I'm sure he's getting good advice from some very smart people. And just looking at it from the outside, I think he could do it, but he may have very good reasons for not doing so at this point.
One last topic, the commutation of the prison sentence of George Santos, former congresswoman, very briefly. This was Santos over the weekend explaining how he found out that his sentence had been commuted by Trump.
I had no expectations. I wasn't even aware until I learned it off of the chyron of mainstream media inside of the prison myself. I had just been released from segregated isolation after 41 days for absolute no valid reason other than retaliatory warden.
So
But
sorry,
I learned it from the TV.
Yeah, so I mean, that's incredible. You were standing in prison, you looked up at television, and that's where you saw that your sentence was commuted?
More like I didn't see it. Other inmates saw it and called me over to see it. I was not in the room at the time, and then I made my way to see it. I called my family, and they told me it had happened, but I was not aware. It was a surprise.
And on his critics?
Pardon me if I'm not paying too much attention to the curl clutching of the outrage of my critics and of the people predominantly on the left who are going to go out there and try to make a big deal out of something like this. It is known that presidents have the power of the pardon and the clemency, which are plenary, and they're extended at their will.
Well, that's true. The question is whether this was a good judgment call on Trump's part. I mean, it seems to me, George, that this is just a Trump sticking his finger in the eye of any and every Biden-era prosecutor and prosecution he can to do some score settling here. Because, I mean, George Santos is not a particularly sympathetic figure.
Well, that's true, and but Trump does have the authority to do it. And, you know, if you look into the history of these presidential pardons, Bill Clinton pardoned an awful lot of people on his last day in office, and
so
a lot
did Joe
of them
Biden.
were people. Yeah, and a lot of them were people who had contributed mightily financially to Clinton and his campaigns. And you got to wonder, is Trump? You know, Trump clearly has the authority. I don't think Trump needs the money. I don't think Santos ever did anything for Trump.
No.
I mean, Santos was just basically an embarrassment and a problem.
Yes.
But here Trump did it, and I think he may very well be right. This is just Trump's, you know, jamming his thumb in the eye of his critics.
Yeah, and now George George Santos can go back to Brazil and ply his trade as perhaps his alter ego or something. I don't know. I don't want to know, actually. George Parry, former federal and state prosecutor, regular contributor to the American Spectator. He blogs as Knowledge is Good at knowledgeisgood.net. Knowledgeisgood.net is where George Parry blogs. George, thanks as always. Appreciate it.
Okay, always a pleasure.
And George Parry joined us on the Turnkey.pro answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer.
Signature Bank is Chicago's fastest growing independently owned business bank. It's a bank that cares about your business and is invested in your success. I'm Dan Proft, and I know this because Signature Bank is my business bank.
Hi, I'm Chris Johnson, CEO of Classic